In a big relief for home buyers and the central government, I can say the Bombay High Court upheld the constitutional validity of the Real Estate Regulation and Development Act, also known, of course, as Rera, observing that it was crucial to protect the interests of flat buyers across the country and develop incomplete projects. More importantly, the honourable judges noted that there are enormous problems in the housing sector of India and said it's time to take a step forward to fulfill Mahatma Gandhi's vision of wiping every tear from every eye. The court also addressed the issue of slow implementation of the Act, saying it must be closely monitored. Hello and welcome to Urban Reality. I'm Anisha Natarajan, and today we'll decode the judgment to understand what it now binds builders to and also look at the reality of RERA's implementation across India. Joining me on the show, Abhay Upadhyay, President Forum for People's Collective Effort. Also with us from Pune, Rohit Gera, MD Gera Developments, Girija Balakrishnan, partner at Malvi Rancho Das and Company, who was representing the Forum for People's Collective Effort, will join us on the phone line to give us an update on what happened in the court yesterday. Executive Director Knight Frank Ghulam Zia is also with us. So is Avikshit Moral, partner at Juris Corp. Everybody, thank you very much for joining me. Let me straight dive into it. Abhay, has this come as a relief? Were you even surprised? Was it even a battle at all?
Yes, Manisha, it was a big battle, and I'm thankful to our solicitors, and Girija is here. She has really done a lot of hard work, and now the judgment which has come, it is a victory for the home buyers. And the good part is almost all the sections, except with regard to the judicial member in appellate authority, almost all the section, each and every word has been held to be constitutionally valid. And now it should be put to rest as far as whether the act is valid or not. And I am sure now government, including state governments, have taken note of this. And the good part is the judgment has said that the problems which home buyers have been facing, and so implementation, now everything boils down to implementation part.
All right. Okay. Let me then go to Girija. Girija, I've in parts got some information on what the judgment reads. As I see, two things were challenged by the builders. Number one, why they basically said, why are we being asked to put 70% of the project money into an escrow account, especially for projects which were ongoing before RERA, saying that it is a superimposed obligation, which the courts have said nothing doing. The second was on penal interest to be paid. Can you just outline it for us and tell us what was the precise judgment and how does it now help buyers or solidifies their position?
Okay, basically on the 70% deposit, the promoters had challenged it on the basis that this was a retroactive legislation and it was therefore unreasonable to them. But the court basically looked at it from a consumer perspective, and they said that the promoter should not be entitled to divert any of the monies collected for a project for any other purposes, and thereby putting the entire project in a jeopardy, which I think has been a problem that's being faced across the real estate sector. So that's on one point. But with reference to the actual interpretation in terms of what constitutes a 70% deposit, there were arguments which were addressed in court in terms of whether it was only the amount which was to be received thereafter from a allotee that had to go into the special account, or whether it was all monies received from the allottees which needed to go. Over there, I think the court has taken a balanced view and have held that insofar as past deposits are concerned, if the promoter comes forth and furnishes a certificate to say that the money has been spent on that particular project, then that money need not go into the escrow. So the court has tried to balance, the interest of both the promoters and the allottees on 70% deposit.
All right. On the penalty, can you give us an outline on what the courts have really ruled and if there are any grey areas left or none at all?
On the penalty, basically the court is very categorical, and they've said that these monies are not in the nature of penalty but more in terms of compensation, because the court realizes that the promoter is actually an agent in that sense of an allotee, and therefore that the the flat purchaser allottee should be compensated for, a delayed delivery or for not being given what's been promised. So they've upheld that compensation.
All right, this is fantastic. I mean, both these aspects which were being challenged. Rohit Gera, come in here from the developer's point of view. I know Narendra and Credai have both come out with statements saying we welcome it, but is this, just for a few handful of developers at the top who have anyway been doing a good job, or is that the sense in the developer community by and large that, look, now we've got to follow these rules, there is no other way out?
Manisha, I think personally, I think this is a very positive outcome because what people don't necessarily realize is that the uncertainty that this causes is tremendous, and then consumers are unsure about what's going to happen. Therefore, they defer their purchases. So I think that there's a finality to it, and to me, that's the single biggest benefit of having a very clear judgment, which doesn't even refers anything back to any government to kind of relook at. So I think it's fabulous that it's come out, it's clear, we have to follow it. And to answer your the other point that you raised, look, it has been a fact that developers functioned in a way which was totally unregulated because there were no regulations. That was the norm at one point in time. Some of us functioned in a more systematic manner. There are many, like you have acknowledged, that there are many who have functioned in that manner. For them, it doesn't matter. But eventually, I think we have to keep the customer at the center of everything we do. And now Rera will enforce it. Those who have the ability to do so will continue to be in business and continue to thrive.
Right.
And if you don't have the ability to do this, well, please pack up your bags and leave the industry.
Okay. The only outcome which could have possibly been better, and I'm going to just, read this one out, the one-year extension period citing force majeure as the reason for completion because of circumstances beyond control. The court has given some sort of a guarded relief to builders to actually go. My question is, Ghulam Zia, is it now likely to be that, a lot of builders end up using this little guarded exceptional cases rule that High Court ruled yesterday by builders to clog Rera?
Well, it's something which will be jumping to conclusion if you believe that everybody will start doing that, because as we have obviously acknowledged that there are people who don't really always cheat or who are there with wrong intentions. But I agree that a lot of these projects, one of the major causes of delays was because of regulatory time taken for getting permissions and so on and so forth all over the country. So that is one, I'm sure the honorable judges would have realized that this is one of the key reasons for this whole stumbling block. So they have acknowledged that you may get some extension whenever it is something like this coming up. And to me, it's only logical, because otherwise we were creating a situation where developers were not in a position to even deliver. If you look at last year and a half or two, hardly any new project launches have happened. It is purely because most of the developers are unable to fathom, to understand what are the Reras today asking them to do. So all these clarities that we're talking about, whatever happened yesterday, will only establish faith from all stakeholders' perspective, like even a consumer. Buyers are not coming in and buying. As Rohit was talking about, there are so many buyers who are still waiting on the fringes to actually understand Rera better before signing the dotted line. So the more the clarity emerges, the better it is for the whole industry, for all stakeholders.
Okay. Avikshit Mural, do you think that the developers are likely to now challenge this verdict in Supreme Court? How likely is that situation? Or do you think that, ruling is clear enough and they probably may not go higher up?
No, Manisha, I have a sense that there will be an appeal that will be preferred against this order. But if I can just take a minute on the point that you were actually talking with Ghulam on the force majeure part, I just had a point to add here. So basically what had happened, there was an order that has been passed by Rera early this week, where actually there was a relief that was granted to one of the developers on account of certain circumstances beyond his control. And if you go through the order, it was a detailed order where actually they have kind of bought out the circumstances in which such a benefit can be given. So yeah, as like Ghulam said, yes, it can't be misused very easily just because there was a passing remark by the High Court judges. We have some sort of precedent as far as this is concerned.
All right, okay. So developers likely to challenge it, and of course Supreme Court can also now take up Karnataka and Jabalpur builder cases. Still a lot of cases are going to be needed, or at least Supreme Court ruling will be needed before it becomes crystal clear. But we're going to come back after this break and discuss what is happening on Rera implementation. Now, many a slip between the cup and the lip. 6 months or more than 6 months have passed since it was notified by the centre, yet I would say that the implementation leaves a lot to be desired. Stay with us.